Did you get swarmed? Bunch of kids just left the room. I thought you got swarmed. I'll give you a second to get ready. Looks like the parties are ready. We'll begin. This is the case of State versus Clark. Mr. Simmons, you may begin.
May it please the court. Good morning. It was about 6.5 years ago that I stood in this very same spot and argued State versus Davis to no avail. That case is very important to the case we are reviewing today, because in Davis, the law enforcement officer provided pretty much a textbook example of how an officer can balance the need for an OWI investigation with the defendant's right to make a phone call to an attorney. The facts in Davis are what is most important here, because
you said at the time, though.
one fact I thought was really important, but you did not. But the thing is, you might recall there was an accident which was not caused by Mr. Davis, which is here nor there. But at the scene, it had been snowing, the pavement was wet, it was not safe to do field sobriety tests out there. The officer did conduct an HGN out there, and he did smell odor of alcohol. So he determined to go to the Sally Port of the jail to complete the field sobriety testing. What is important to this case is that the officer was present when Mr. Davis was discussing contacting an attorney with his wife, and then Mr. Davis was placed in the back of the squad car, and he asked the officer at that time if he could call his wife. The officer said, "You will have that opportunity, but not yet. We have other investigation to complete." But the officer took a great step in then going to the wife who was on the scene and getting the defendant's cell phone to take to the jail with him. And he told him, "We're going to do some more tests at the jail. When I have your cell phone, when we get to the jail, I will give you your cell phone and you'll be able to make calls." They did the field testing in the Sally Port. And then when the officer was done with the testing, he arrested Mr. Davis. And here's another very important part. He walked him right into the jail and put him into an intake room, handed him his phone, and told him he could call anyone he wanted. Mr. Davis called his wife, and he called his attorney.
Is materially different in this case. If I have the facts correct, they sat Ms. Clark down, told her she could make a reasonable amount of phone calls, put the phone right in front of her, and then according to the tape, at 6:54, 7:14, 7:21, 7:27, 7:49, 8:01, 8:07, 8:15, told her, that's 1, 2, 3, 4, 5, 6, 7, 8, 9 times that she could make a phone call with her phone in front of her. So what's the difference?
First of all, the statute, 804.20, important language. It doesn't say without unreasonable delay to provide a phone call. It says without unnecessary delay. Now, when they had her go through booking first, that wasn't necessary. They had her in custody in the jail.
Took 11 minutes. She got into the booking room, or whatever you want to call it. They do whatever they have to do. Read her Miranda, read her, and gave her a written copy of implied consent. and then, of course, the statute at issue, the 804.20 notice, and all of that makes perfect sense. Why would I give somebody, why would it be unreasonable to say you can call your lawyer as soon as I read you a reason why you might want to call your lawyer? He hasn't even yet officially asked for her to submit to the alcohol test. So how can that be unreasonable? And it happened all in the span of 11 minutes.
The statute says, without unnecessary delay.
Any of those aspects be unnecessary?
Because if you look at the Davis case, that officer didn't find any of those things to be necessary.
Are the facts of this case, and by the way, the way that I've seen the video and I saw a still, her phone was as close to her as my phone is right now, just right there. I mean, everybody sits with their phone. I bet your phone's close to your table. It was right there for her to use. So talk about the facts of this case, and I think he said 11 times she was said, you can make a call, you can make a call. How is any of that unnecessary?
Those calls come after the implied consent is read to her and she's asked to make a decision. And then they say, if you want to call somebody, call somebody. But then, you know, I think that's unnecessary delay because there was no reason to book her. There was no reason to go through all that. She had already asked for her attorney before she got to the police station. And as you...
Book her.
She could be booked later. I mean, that's what the officer did in Davis. He just walked him in the jail, sat him down in an intake room, and gave him his phone. It's not, booking is not an emergency procedure.
About her hearing impairment, and I think nobody on this bench is going to deny that she certainly had a hearing impairment. It was written on her license, her driver's license. She was wearing hearing aids. She mentioned it on the scene that I have a hard time hearing, and here's my hearing aid. But I find it interesting that during the booking stage, never once was that an absolute, because of that, we need to do something different. She didn't hesitate to say, I need my glasses. What happened, what transpired during this interaction where the officer should have done something different than what he did? Because she was definitely nodding along, communicating, responding appropriately. We could hear it, we could see it. Tell me what could have been done differently.
Could have been done differently is, and this is what the Court of Appeals did wrong in their fact findings. What could have been done differently is her phone is handed to her directly and said, well, with the covering sheet over it, which remained.
But they gave it to her, and she said, thank you. And then a few minutes later, they put the implied consent on top of it in her vision. I mean, she saw it happen.
Also telling her at the time he set the cell phone down that she would be able to call an attorney. It's not clear whether she's saying thank you about that or thank you about the cell phone. She testified her cell phone was never given to her. She didn't remember seeing it. So that sheet goes down on the cell phone very quickly. And when you get into the Hicks analysis, which the Court of Appeals did not do a Hicks analysis on whether or not she had a reasonable opportunity to use the phone and whether or not the officers took affirmative action to make sure that her request to call an attorney was honored. That's what Hicks is about.
Hiring a suspect with restrained liberty, which I don't believe your client was cuffed or anything like that. She was definitely in a booking room, but she wasn't restrained. But requiring a suspect with restrained liberty to affirmatively pick up a police department's telephone, that's completely different than these facts, isn't it?
There's any fact in Hicks that he was handcuffed. The restrained liberty is being in the custody of the officers in the intox room. Pardon me?
To pick up the cop's phone. That's very different than these facts, aren't they?
But why not hand the phone to her and say, here, you can use your phone? Now, the rookie officer, Cheeseman, testified that he believed the booking staff would have told her she cannot make phone calls with her cell phone in the jail. They didn't.
I mean, what is your argument? Are you here arguing about the time? Is it the lapse of time? Do they have to give her the phone as soon as she comes through the door and explain to her that she can make phone calls? What is the legal argument you're making? Because I think I would be hard pressed to say it's unreasonable within an 11-minute period to hand somebody a phone, tell them 9 different times you can call anybody, and this is a violation of the statute?
On that is that the statute doesn't say unreasonable amount of time. It says unnecessary delay.
Tell me what is allowable in your interpretation of the statute? What can the police do before they hand her the phone?
Well, let's say if we accept that they can have her booked, which is unnecessary. I don't accept that they can have her booked, but if we accept that they could have her booked, she went through that process. She didn't have her phone. She went through that process. Then they took her to the intake room. I think they call it the intox room in Burlington. And then they set down her phone, they cover up her phone, and then he starts reading all this legalese to her.
To the case, I'm asking you, under your interpretation of the statute, what can the police do upon the second they enter the jail?
They should do what the officer did in the Davis case. Bring her in, set her down in a room, and give her her phone.
There's a 2-hour deadline requirement, and I have been a part of many OWI cases. Sometimes cops are up against a deadline. They have to invoke implied consent to get in that magic 2-hour window. And I have seen many cases where defendants who are given that chance to talk to their lawyer, I imagine some of the conversation is, you're up close against 2 hours, let's keep talking, and they're still talking to their lawyer. So then an officer risks missing that 2-hour window. That doesn't make sense to me, that she gets to make her phone call before he gets to start the clock for implied consent.
In this particular case, there was nothing like that. Everything moved very fast, and the state kept emphasizing how fast everything had moved. There was no problem with the 2-hour limit at all.
A long time. Who knows how long they're going to talk, and a good lawyer might advise his client, let's keep talking. They haven't invoked it yet, keep talking.
That's in the officer's control. If he says, look, we have a time limit here, you can call your lawyer back, but now I'm going to have to read the implied consent to you. That's a different situation.
You as well. There would be a motion to suppress filed that the cop cut off her opportunity to visit with her lawyer.
There's always motions to suppress, filed if there's an issue to argue about.
Be looked at pragmatically. And the cops are given an opportunity to do their job. So as Justice McDonald was asking, you're saying that they have to immediately give the phone and let her call her lawyer before the cop does any of his paperwork?
That would be the ideal situation.
Ask you this, counsel. Did the cop produce unreasonable delay in violation of 80420 when he took the 32 seconds maybe it took him to read the 80420 rights to your client? Was that a violation in your mind, reading those rights?
Necessary. And you said unreasonable also. The statute doesn't say unreasonable, it says unnecessary.
How have our cases dealt with that? I mean, there's a list of Court of Appeals cases, at least, in the state's brief, one of which I might have written, that where we said, a few minutes, in that category of a few minutes of going through these ordinary things that happen when a defendant gets to the police station, that's the way it's been interpreted.
And there is no reported law on this particular issue as to whether unreasonable delay equates with unnecessary delay. And I say they're two different things.
There was a situation where there had been, the defendant had fled from a convenience store and then picked up a gun, and the officers were trying to get the gun back. People are nodding, remembering that. And I think and we did decide that there wasn't an unnecessary delay in that case because the officer who was questioning the defendant in that case kept putting him off when he said, "I want to call the attorney," and the officer kept saying, "Well, you can do so after we get through and take care of this stuff." And I think we talked in detail about what unnecessary meant, and it doesn't mean, like 30 seconds or 11 minutes or, things that are kind of customary as far as a normal procedure like booking. Reading the statute, which was a service to your client, they didn't have to do that. It doesn't really mean those kinds of things, does it?
And the facts of the case that you're referring to, unnecessary, meant something different than it does in this case. In this case, she had been perfectly cooperative all the time. There was no reason to delay her call that she had requested before she got to the jail. And I see I'm over time.
Back.
Madam Chief Justice, and may it please the court. Good morning. My name is Josh Duden, and I have the privilege of representing the state of Iowa in this case. There was no unreasonable or unnecessary delay in this case, and the basic baseline text of Section 80420 speaks to the fact that, as this court has repeatedly held over the years in 52 published cases at least since its inception, that the term has a regular pragmatic meaning. So beginning with the statute's text in 80420, the law speaks truly to an unnecessary delay, which is not very different from an unreasonable one. As Justice Mansfield referenced, I believe it's State v. Starr,
I just found it, yes.
is a 2024 case that is not cited in our case. I believe it post-dates or was after our briefing was completed specifically. But regardless, State v. Starr is instructive as a 2024 case for what could be considered unreasonable. In Starr, the delay took, I believe, several hours, and there was a staunch delay between when what was claimed to be a public safety exception would apply, between when a gun would be potentially found and whether or not the community's safety was truly at issue. That isn't the case here in an OWI statute context, but it is helpful. And it's helpful because it speaks to something broader. In fact, in State v. Starr, this court held and explained that really the broad language used within Section 80420 can incorporate any number of delays that may be necessary for public safety purposes, which was not met in that case, to be sure, as well as the Court of Appeals has recognized in at least one case, certainly, that Justice May authored from his time on the Court of Appeals, that delay could be for administrative reasons. So the statute's plain text permits a number of options. It speaks permissively. And as this court has recognized over time, that permissive nature is one that it is not self-executing or self-enforcing.
One question I think the defendant has an interesting point on the fact that the statute uses unnecessary delay in the part that we're talking about here, and it uses unreasonable delay in a different part. And as your friend on the other side was pointing out, maybe we should try to figure out what the daylight is between those concepts.
While there could be a drawn distinction because different terms are used and within the principle of statutory construction, the use of different terms could be something that could be applied differently. But what is unreasonable and unnecessary could very well mean the same thing like they do in this case. For instance, to give an example, the jail booking procedure was something that was spoken to specifically here. It took about 6 minutes for Ms. Clark to be booked into the jail. I would believe that according to the further review application at page 14, it's conceded that the, quote, administrative booking process was efficiently and promptly completed by the jail staff.
Getting her signature on the, when she said she was going to refuse the breath sample, getting her to actually sign that before she was allowed to call, is that a necessary step?
I believe that it would be I'm going to say no, it's not a necessary step, but it is possibly a desirable one.
Isn't that kind of contrary to the purpose of 80420? So when I reviewed the video, it seems like Ms. Clark is standing in front of the computer because she said she's going to refuse, and they ask her to sign, so they want her to sign in the computer. And I think she asks again if she can talk to her attorney before she does that. And then the officer just says, okay, you're refusing, so go sit out there. And so she still doesn't really have an opportunity to call her attorney at that point. That's kind of the, so does that, her request to call and still not, the fact that the phone might have been sitting there when she was still sitting in the chair before this time, and she could have made a call, does that somehow negate the fact that when she was standing in front of the computer to sign that she was going to refuse and ask for an attorney, does she still have that right at that point under 80420?
Yes, her right would continue to the point when she was then restrained and ultimately charged. The court has drawn distinctions between, I believe it was in State v. Robinson in 2015, the court drew a distinction between the time that an individual could be charged or the formal restraint of being incarcerated and when this is kind of a pre-incarceration or post-arrest procedure. Certainly her 80420 rights would attach here. But there's really no clear distinction because what is an opportunity is not a mandate for the officer.
I mean, following up on Justice Oxley's question, kind of watching the video, it's almost like they're, ships passing each other, and I don't know what we make of that. She keeps saying, she never says, I want to call my attorney that I heard, or let me phone my attorney. She keeps saying, I want my attorney. One point, I think she says, I need my attorney. The officers keep saying, you can call your attorney. So what do we make of that? Because I do think at one point at the end, the officer says, after she says, I need my attorney, the officer says, look, first do this, give us this refusal.
If I understand the question correctly from the distinction standpoint, I believe based upon Exhibit 1, at least the minute marker, she requests at least 4 times while in the room if she can call her attorney, which would amount to approximately 9 times, as Justice McDonald pointed out, or 11 times if we include the context of the field, I believe, as well, as Chief Justice Christensen pointed out, that she references potentially calling her attorney. Can I call my attorney? Can I have my attorney? She references it both possessive, that she seems to appear to have someone in mind, but also that she takes no active steps or makes no real effort to access the phone.
I just heard, I need my attorney.
I have a couple questions on the placement of the phone. The first one is, I kind of consider it to be about halfway between her and the younger deputy. So who actually had control of the phone? Because there is a disparity of power in that situation. And then I have a follow-up question for that.
Certainly. The controller custody of the phone was available to Ms. Clark. And I think that's what's important here is that the statute doesn't speak to placing it exactly in her hand, but rather making sure that she has an open opportunity and a real opportunity to.
Question, you're right. The statute doesn't say that, but there's something in there that gets my attention that hasn't been talked about. If such person is intoxicated or a person under 18 years of age, the call may be made by the person having custody. When we look at Ms. Clark, should the deputy, is it reasonable for maybe the deputy to have considered that to be a form of a disability? I mean, it is a disability, but that section there in 804.20 is almost, I mean, minors are legally incapacitated. A person who is intoxicated, well, obviously he believes she is, that's why she's where she is. Couldn't he have done more? Couldn't he have placed that phone, even though it's between them, picked it up and said, here, use your phone, or put it in her hand? Is that unreasonable for a person who's wearing hearing aids and maybe is getting some mixed signals, what to do?
I don't think the placement of the phone is unreasonable. I think the state's position would be, just as the district court and the Court of Appeals found, that placing the phone in front of her for what is an unobstructed about 44 or 45 seconds, clearly within her view, as to acknowledge it and say thank you, allows her a meaningful opportunity to access it. Certainly,
At Starbucks together as friends, But if I'm sitting in a booking room and it's the deputy who just did that, isn't that a different scenario?
This court has not drawn such a fine line or distinction previously. Should Hicks be at issue, one thing that's noted in Hicks, and I believe Moorhead as well, is the proximity or availability of the ability to make those calls. This chance would be, in this case, it would be that phone is right in front of Ms. Clark.
Asking her questions when she said, I want to call my attorney, the phone is sitting there, and he says, your phone's there, and says you can make calls, but then he keeps asking her questions that suggests that she doesn't actually have an opportunity.
If I understand the question correctly, it is whether or not there's a distinction between the ongoing discussion or the gap space between when she's actually being advised of her rights and how long she would actually be able to make those calls?
Or I think it was before he placed the paper on over the phone, that's when he gave her for her to read along. And she said she wanted to make a phone call, and I think he says you can make a phone call. But then he keeps asking her questions. It seems like, at least the way I interpreted the interaction, it was going to be, you're going to be able to make a phone call later, but maybe that was me misinterpreting what was going on.
If I recall correctly from Exhibit 1, at least the footage from, I think it's Deputy Cheeseman's body camera footage, it shows an unobstructed 44 seconds where it's also uninterrupted from her being able to access her phone, or at least see it. Her phone is distinctive.
And where the cop's not asking her any questions, and she could have just picked it up and used it.
Believe so, yes. And the record would stand for itself on that point.
Argument 804.20 was violated. Can you talk to me a bit about sufficiency of the evidence?
Certainly. Sufficient evidence exists to maintain and uphold the verdict here. As it relates to issue 1, the court's deferential standard to the verdict here would speak to the fact that when Ms. Clark was first stopped, she almost hit an officer in the turn lane. The officer had to tap or bang on the side of the car, the hood, I believe, to tell her to stop and then remind her ultimately as well to put the car in park. At this point, Ms. Clark hadn't advised that she had any noticeable hearing issues or significant hearing loss or use of hearing aids at this point. I believe her hair covers her ears, but certainly the record stands for itself there. She just demonstrated a noticeable nystagmus, said in response to the first question if she had been drinking that she had been drinking, which is consistent with her kind of driving behaviors that became aware of through not only reports of others and causing the responsive conduct of the officers, but ultimately what allowed them to also prompt further investigation. And she required assistance getting out of the car, grabbing onto the car for support, as I believe both deputies testified to as well. And the video, again, stands for itself.
On the 804.20 issue, my concern with this is that there was never a point, as I watched that video, where the officer says, here is your cell phone, and you can make the call on this phone. Instead, it's sort of placed in front of her, and then there's a paper placed over it for most of their discussion. And even when she asked to make calls, or at least asked for her lawyer, the questions sort of keep coming. And so there's never a point where it's, if you want to make a call, now is your time to make the call. And you can make it on this phone here and not some other phone that they might have, wired in that room. And in Hicks, we say, even if a phone was in reach, we do not think that alone suffices to provide a detainee a reasonable opportunity to contact family. So how do we wrestle with all of this where there's never a statement, this is the phone that you can make that call on? Because it doesn't seem to me that she understands, if I want to make the call, oh, it's on my own phone?
Certainly. Maybe Hicks is also instructive if we continue on. That is, to the extent to answer your question, Hicks draws a fine line distinction between what is available. In that case, I believe the phone was not visible from the actual camera footage. Here, the phone was certainly available and visible within reach. Hicks also speaks to what is to be used as control. Can she reach for it herself? Because the phone wasn't visible there, it's reasonable to think that the court's decision was based in part on the ability not to be able to reach for the phone or access it. Ms. Clark herself, though, may be the best evidence here. In her testimony, she said she can't use normal phones based upon her hearing loss. And so when she was advised...
Did the officer know that? I mean, it strikes me that she didn't think that she could just pick up her phone and start texting or start surfing the internet or start going to social media. that the phone was there, that it was her property in front of her, but it wasn't her property for her to use to make a phone call at that time. And that's what I'm struggling with.
Based upon the Hicks distinction of what's reasonable in access or availability control or knowledge, it is, I believe as Chief Justice Christensen pointed out earlier, the knowledge that one could access their phone when you're being told perhaps 9 times, 4 times, or 11 times that you could use the phone accordingly. She had every opportunity or chance, which is what's required by the statute. She simply didn't choose it. And maybe Ms. Clark's own statements are the most instructive because she waited no time between when they said you have the absolute right to call and make the calls, contact your attorney and see if you want to. At the end of this, I will be asking you to whether or not you're going to consent or refuse to providing a sample of your breath. And she says, I'm going to refuse it without missing a hitch. Perhaps even more tellingly, she does so again when they confirm, you're going to refuse it? Yes. Or I believe is how it's documented when I transcribed it at least. And they say, okay, another deputy comes in and then again confirms. And at all points in time, she had the opportunity, the chance to contact her counsel, the attorney that she continuously referenced. She just chose not to. And so as this court has held previously, the officers are not to shape the context or the way that a person would execute their or employ their 804.20 rights. In Garrity, I believe in 2009, this court said that the officers have a duty and an obligation when a person invokes their right to counsel to then notify them of the individuals who they could call. In this case, that is by reading them the verbatim 804.20 notice in the implied consent statute.
4.20 has been violated. What evidence must you lose?
That is a good question. Certainly, the matters that have been taken out would be anything in this court previously. It would be the exclusion of evidence that would be, I believe, McMickle speaks to it specifically, a 2023 or 2024 case from this court, which would be the exclusion of at least the statements at issue, the refusal at issue, and then anything that would be from the wrongful invocation after, much like the Miranda warnings would constitute. The video would have to be, I believe, probably split. That is, there's a distinction between when the video is being reflective of her performance on field sobriety testing or her driving behaviors, the initial interactions, which certainly her 804.20 rights had not attached at that point in time. Her non-testimonial conduct would be still permissible, that is her performance on field sobriety testing, and ultimately her failure as well. But consistent with this court's other decisions down to I believe Garrity as well, dating back to at least.
I guess I should have made myself more clear. I meant the video at the booking, at the law enforcement center. What part of that video would you lose?
Well, the functionally usable part of the video would be anything that when she was in the booking room, probably after the invocation. She was in the place of custody. Her rights had attached. She was at least restrained. And then at that point in time, she was then going to refuse. So I think anything after what would be about probably minute marker 6 or 5, I believe, if we're going by the booking video footage. And that's because for the next 6 minutes or so, that interaction speaks to her refusal, and it speaks to her notification and the invocation of her rights. Most of it wouldn't be usable anyways, because within the context of commenting on your right to counsel, your right to remain silent, things like that, that wouldn't otherwise be permissible. It wouldn't be functionally usable at a trial level anyways, but her refusal would certainly likely be excluded, at least under McMickle. Thank you.
Thank you. I want to get back to the pragmatic nature of the way the statute should be treated. And along that line, what Hicks said is we think we have to liberally construe this statute to say that police officers have an affirmative duty to make a phone call available, and that handing her phone to her, giving her permission, that's what the statute says, give her permission to make a call. That is a necessary affirmative action. You can't, I don't know if the officers were playing a game with putting the implied consent over the phone or not. It doesn't matter. They do nothing to show her that she has permission to use her phone. And it's that disparity of power when she's in custody.
You tell her at least 6 times that she can make a phone call. I mean, isn't that permission to make a phone call?
She can make the phone call.
Doesn't, the more senior fellow, Phillips, doesn't Deputy Phillips gesture and say, pointing to the phone, which is on the paper? I mean, you can see it on the video. You can make a phone call.
Of course, she testified she never even saw the phone, but in any case, why not just hand it to her? Why not accommodate? Why not take an affirmative action?
Permit. It doesn't say facilitate. It doesn't say you have to put the phone in the physical possession of the arrestee. It doesn't say you have to unlock the screen. It just says you have to permit the phone call, and they hand her the phone.
Court said we have to liberally construe that permit to mean you have to take affirmative action to accommodate her phone call.
Has to physically put it in her hand, that it's insufficient to put it in front of her.
To her, or at least shove it in front of her on the table and say, you can use your cell phone.
He put the phone within a foot of her and said, you can make a phone call. Would you agree that the rights have been satisfied? How close does he need to get the phone to her to satisfy the statute?
Proximity. He needs to give her permission to use the phone. He needs to say, you can use your cell phone to make this call. Remember,
Record, and it's, he said, he was generous. He said a foot, I think. It's 2 inches from her. And you said she didn't see it. From the picture I'm looking at, she's looking right at it. So assume those facts are ascertainable from the record. How does that change what you're arguing?
well, again, they set it down, but they didn't say you have permission to use your cell phone to make this call. And remember, the rookie testified that she would have been advised by booking that she cannot use her cell phone in the jail. I think you also really need to look, when we talk about the affirmative duty of accommodation, you have to look at the way the officers are approaching her when they're pressing her for an answer as to whether she's going to consent to the test or not. And the veteran officer, Phillips, actually approaches her as she's sitting back in a corner. He's standing and he's approaching her. She's covering herself up. I don't think this is a picture of affirmative action to accommodate a call to her attorney. I think a nice, calm conversation about you don't have to decide right now what you're going to do if you want to talk to your attorney first. And that's the whole idea between 804.20 is to have that opportunity to talk to counsel.
You a question earlier, and I want to make sure I understand your response. Is it your argument that reading the defendant her rights under 804.20 violates her rights in 804.20? Is that what you said?
It doesn't violate her rights. It is a factor to take into consideration on.
And that reading the 804.20 rights was unnecessary, and therefore it was an unnecessary delay in violation of the statute.
She had already requested to speak with an attorney, though. It wasn't really necessary at that point, you know, and
It's reading her rights under the statute is a violation of the statute.
of the case.
I mean, is it an absolute sense of, I don't know. I mean, you could think of it as being necessity is only when if there's bombs going off in the station or something, you know, extreme violence. I mean, what is necessary to you?
And I think in one of those Court of Appeals cases, they talked about there needed to be a pat down. That's certainly necessary anytime you take somebody into custody. The booking procedure and the reading of the implied consent before she made her call, Davis shows, that officer shows, you don't have to do that first. It's not necessary to do that first. You can sit her right down in a room, hand her her phone, and tell her she can call anyone she wants.
Could you address the remedy? If we find that 80420 was violated, what evidence gets excluded?
I think it has to be the entire video and the entire interview, testimony about the interview at the jail. Because she requested counsel before they went to the jail.
But don't we have case law that covers, okay, but that's not when 804.20 kicks in. It kicks in when you're at detention. So why should that video beforehand be kicked out?
The video out on the street, I'm not saying that. I'm only saying at the jail.
One, aren't there? Aren't there, how many videos? There's like 4 or 5 videos.
There's squad car videos and body videos and,
Are you saying the one that would be excluded would be the one in the booking room that we've been talking about? For the whole thing?
and any testimony as to what happened in the booking room. I see I'm well over. If there's no other questions, I'll let you go. Thank you.
Clark is hereby submitted, and the court will take a brief recess before we have our afternoon oral arguments as well. Thank you, schools, for being here. Court is adjourned.